All right, great.
Meeting is being recorded.
Let me see if I can get the screen share going. Oh, hang on. All right, can everybody see my screen?
Yes. Yep.
That's a yes.
Yes, I can.
Okay, well, good morning. Good morning, everyone. My name is Cynthia Daughtrey, and I am the owner of Beyer Associates. I am a sole practitioner law firm. I used to practice down in Denver in Littleton, and in July, we sold our home and moved up to the Steamboat Springs area. We live in a little town called Hayden, which is just west of Steamboat Springs. And today I'm going to talk about what happens if something happens to you. Will your family be left with a big mess, unable to support you as you desire, or what really happens if you have a will or if you don't have a will, and kind of talk you through all of that. So our law firm that I have here, I practice estate planning. We also do a little bit of probate. In addition to that, I also help people if they're in the process of forming a business to make sure that we've got the right documents for your entity. I also do real estate contracts, and so I'm available for any of that other type of work. Okay, let's see what's going. So what happens if something happens to you? Is your family going to be left with a mess and unable to support you? So what we're going to talk about today is the state's plan for you and why you might want to opt out of it, what simple form documents do, and what happens if you just have those simple form documents. You can go on ChatGPT, and ChatGPT is wonderful for a lot of things, but it may not fit what your family needs. The other things we'll also talk about today are what are the next steps if you want to be sure that your family will be well taken care of if anything happens to you. So first, the basics. Take a look and do you have a will? Some people do. Some people might have a trust. There are a couple of different kinds of trusts. There are revocable trusts, and then there are irrevocable trusts. Depending upon what you have, that is going to dictate what the state will do for you. If you have nothing at all, no will, no trust, no documents, the state of Colorado, according to their statutes, has what exactly happens to which heirs get to inherit. What's the order of priority for them? Um, and so sometimes that plan may not be exactly what you want. There may be a special set of china that you want to make sure goes to that favorite niece. And if you don't have it written down, it's not going to go to them. The other thing that happens if you've done estate planning, it may not be the right plan at this time in your life. I always recommend to my clients that we take a look every 3 years to make sure that everything's up to date. Things change. Sometimes people have grandchildren that need to be included. Sometimes there are children where there's a separation, so to speak, and they may not be in the will anymore, and you need to make sure that you've got that. Another big thing to take a look at is the accompanying documents that you might have. And so what am I talking about there? Um, the basics, as I said, is the process of making sure that your family, team, and clients aren't left with the mess if something happens to you. You do it for them and not simply for you. And yet you can end up benefiting in so many ways because you've got everything taken care of. So the five basic documents that protect you and create that ease and comfort for your loved ones are, and I've got to try to move away the pictures, your will, trust, power of attorney, a healthcare directive, and here's something that you may not have ever heard of. It's called a kids protection plan. So I'm going to talk about each of these down below. So If you become incapacitated, if you don't have a power of attorney, your family can't necessarily go to the bank and access your bank accounts and pay your bills. And it can be also the same thing for your business, depending upon how your business is set up. So for instance, if on your business bank account, it's only yourself and nobody else, if you become incapacitated, nobody else can come in there and take care of things. When you have a power of attorney, within that document, you can determine and set forth all of the things that you want someone to do for you if you are incapacitated. Take care of your bank accounts, take care of real property, take care of contracts, take care of even your digital media. Without having that, if you are incapacitated, what then happens is you have to have somebody go to court to have you declared incapacitated, which costs a lot of money, a lot of attorney's fees, and you may not have the right person that you want appointed as the person that would be your conservator in that type of situation. And also without the planning, you could have the wrong people making the decisions about your money. So one of the things that I always recommend to people when we go through an estate plan is take a look at all your accounts. And I give people what I call a family wealth inventory. We take a look, they insert all of their accounts, all the people on it. So we can take a look and see, is there something that maybe there's a life insurance policy with an ex-husband, with an ex-wife, maybe with a girlfriend, maybe it was a prior relationship, but things have changed. You've remarried, you've divorced, and now you need to update that documentation. Because if you don't, that person might get that. Now, another thing that you also need to take a look at is not just the insurance policies, but also take a look at retirement accounts. Sometimes we forget those. As we start approaching 62, 65, when it's time to say, ring the bell and get into those insurance policies, or not the insurance policies, but your retirement accounts, take a look to see who are the beneficiaries. It might have been a job that you had when you were first married. You're no longer married to that person, and they're going to get that chunk of money if something should happen to you. You need to make sure that you update it. The other thing that's also really important when people put together that family wealth inventory is collecting all those accounts in one spot, because if you don't, your family's going to be ending up going on a scavenger hunt. They may not remember that old job in Wisconsin when you first started out. They may not remember some of these accounts that you've set up. By putting them all together, it's so much easier for your family. So another thing that we talk about is what happens without planning if you become incapacitated. If you don't have the proper healthcare directives, again, your family could have to go to court to get your medical records and make decisions. So another document that I also recommend for clients is actually that. It's a healthcare directive. Within the healthcare directive, this is where now is the time when you're clear-headed, everything's healthy, you can decide how you want to be taken care of. For instance, there might be some people that get into a car accident, there's no brain activity, and they've decided, okay, I don't want to be resuscitated, don't go to extremes, or maybe you want to be in the hospital for if there's only a few days of brain activity or there's nothing there at all. Making those decisions now rather than having those decisions placed on your family when it's such a critical time for them. And that is the last thing that they're trying to decide. Well, how long do we let them live? What were their wills? What was their decisions? Also within that healthcare directive, another thing that I also recommend for clients is putting within the healthcare directive, do you want pain medication? Do you want hydration? Do you want food? Because sometimes people will get to that state where they can't voice anymore of what they want to happen to them. And having all of this laid out within your healthcare directive and your living will gives everybody the exact directions on how you want to be taken care of. Also, if you have that healthcare directive, within the healthcare directive, you also lay out who are the people that can make the healthcare decisions. If you haven't updated yours in a while, now is a great time to do it to make sure that you've got the right people doing decisions. A great example is in my family. So when my mom had her healthcare directive, we had it originally set up with one of my sisters that lived in Minnesota, where she lived part of the time, and then with another sister who lived in Texas, where mom lived part of the time. Well, since that time, we've sold the Texas house. Mom now lives up in Minnesota full time. And so it was just easier not to have the one sister down in Texas because she's too far away than to have another sibling who's there. So we updated the healthcare directive with mom so that now we've got people that are close by. If we need to have a family conference with those people, they can take care of things rather than somebody that might be far away. So we talked about earlier about what happens if you die with no will, that the state has a plan for you. You also, if you don't have a will, then first of all, the parents or your spouse is going to be the one administering the will, or if your parents aren't living, your siblings. If you have no family whatsoever and your family wouldn't qualify for a bond, then the court's going to appoint a financial guardian, and this can run into a lot of money. So the other thing that you need to be careful about in your estate planning when you have no will is, excuse me, is you can set forth in that will, who do you want to be the personal representative? Do you want them to have a bond? Do you not want them to have a bond? So you can kind of guide what happens. So what happens if you don't have planning, if you only die with a will and you don't have a trust to own your real estate or your investment accounts? Your family still needs to go through the court process. So what happens if you have, in the state of Colorado, if you have assets of more than 88,000 and you have real property, you need to go through probate. And probate can be pretty expensive. So sometimes what people will do is they will create a trust. They'll create either a revocable trust or an irrevocable trust. So the difference between the two, the way to look at it is if you have a box. If you have a revocable trust, things can come in and things can go out. So you might have a box that's got your house. You might have a car that goes in. You might have something else that goes in. But you sell the house, so the house goes out and you put the new house in. With an irrevocable trust, that means once you get it in the box, it's locked up tight and nothing is coming out of that. The other thing with an irrevocable will, you have separate trustees that then decide what happens with your property. With a revocable will, with a revocable trust, you can be the trustees on it and you can appoint other trustees on it. When you have things that are in a trust, it does not need to go through probate. So why is this important? This is important because when you go to court and you go to probate, what happens is you have to list out each and every account. So it's like an open book for your life if you don't have things in a trust. So the value in all of your retirement accounts, your bank accounts, checking accounts, savings accounts, vehicles, all of your real estate. And that's all out there. It's a public record for the whole world to see. You may not want to have some of that stuff for the whole world to see. And another reason that you may want to have it within a trust is because when it's in a trust, that is not a public record and it does not go through probate. When it's in that trust, it's essentially it's not the irrevocable word. Once it's in there and it's locked up, but it is locked up in essence so that people are not going to see it because it doesn't need to go through probate. When you have all of those assets that are out there for the world to see, you're also putting your heirs at risk because now people can see that might be a target for fraud. That might be a target for someone to go after them for who knows what. So that's one good reason to have a trust. But you might be asking, well, even if you have a trust, there still might be some ancillary things. So then that's when I have for my clients, what I call a pour over will. So the pour over will is if it didn't get locked up in the trust here, then it just goes into the will, and it's usually a lot smaller amounts, and it's not a big a deal having those small amounts being seen by the public. Another thing to consider is what happens if you have minor children at home. That's where earlier I talked about the kids protection plan. So a lot of us, we never think about what happens if we got in a car accident on the way home. If you got into a car accident, who would take care of the kids? Who knows who you want to take care of the kids? That's why having this pre-planning done by having what we call the kids protection plan. The kids protection plan, you can set out your short-term guardians, you can set out your long-term guardians. And why is that important? Well, in my family, I've got a lot of brothers and sisters. I wouldn't mind having my brother and his wife both together raise my sons if it came to that. But if something happened to my brother and it was only my sister-in-law, there's no way in heck that I want her raising my boys. So within your kids' protection planning documents, you can lay out exactly who you want to take care of the kids. Perhaps it might be a brother and a wife, but if it's just the wife and the brother has passed on, then it could go to the next in line, however you want. If you don't have those wishes, what's going to happen is it's going to end up being a court battle where people are going back and forth. Also within the kids protection documents that I prepare for clients, we also put out all of their medical information. So if something happens, it's all there at the fingertips. We also let the short-term guardians and the long-term guardians know that they're next in line if something happens. Because should you get in a car accident and the inevitable happens, you've passed away, and say the kids are at home with the teenage babysitter, there's a knock on the door. The police are there to inform her what happened, but she can't take care of them. She's a minor. And if you don't have the proper paperwork in place, what's going to happen is those kids are then going to go into Child Protective Services. And then at some point, it'll go before the court to get the proper guardians placed. And this can cause so much upheaval with those children, with already them going through losing their parents. And it might also be a situation that you might have relatives out of state. And if they're out of state, it may take a couple days to get there. But if you have that short-term guardian who might be a neighbor or good friends, you've at least alleviated some of that to make things as easy as you can for your children. Another thing is, what about your adult kids? So one of the things that I also recommend to clients is, as kids are heading off to college, get these documents in order. And I offer a short package for them where it's just the will, healthcare directive, and power of attorney, and just getting these 3 simple documents in place. So if something happens to them at college, you know how to take care of them, even though they might be 18 and you've tagged them out. But at least you can be there to help with the power of attorney and a healthcare directive to kind of talk through things. And these days, kids sometimes, start to have some assets of they're started working and starting putting things away. So by having this in place as they go off to college or even trade school, you're kind of helping yourself and also helping them should something happen. Another thing to think about is your parents' planning not in place? You're the one that's going to be at risk, because if they don't have any planning done, and I just ran into a situation like this. I had a client where her husband passed away. They had no will. They had nothing. So now we've got to go through the process of going through probate. And luckily, they did a few things right. For instance, they had the house was in joint tenancy. And so when a house is held in joint tenancy, what happens is then it's joint tenancy with rights of survivorship. So if it's a husband and wife in joint tenancy, the husband passes away, then the wife will automatically take ownership of that house. But you still need to go through probate to at least get the letters of administration. So when the house is eventually sold, it then can be sold with the wife's signature on it rather than the husband's. So that's another great reason to make sure that they've got their documents in place, because you don't want to have to go to court to get access to their medical or financial records. Another thing too is what's happening with their house, because some people might want to put it in a trust and then delineate within the trust that, after both parents have passed away, then the proceeds, the house is sold and then divided amongst the siblings. Or what happens then, and it might be a significant asset with the house, and if that's the case, then when it goes through court, people are going to know, oh, well, these people got a big chunk of money. And so then there may be at risk for fraud that could be happening with them. So as I mentioned earlier, sometimes people say, well, you know what? I can just go on ChatGPT and ChatGPT can make sure that I've got a will, I got a trust, I've got my healthcare directive, but ChatGPT does not know your unique circumstances. You can also go on Rocket Lawyer and get all those, but Rocket Lawyer doesn't know your unique situation. So for instance, if you've got kids, it doesn't know to go through and ask you to make sure that you've got the short-term and long-term guardians. And sometimes, even if you go through ChatGPT and even if you go through Rocket Lawyer, they're all form documents. And what we do at Beyer Associates, we will go through it to make sure that it's tailored for what you need for your circumstances. And otherwise, you take a risk. You're rolling the dice. And if you like playing Vegas odds, you may win and you may not. But it also could be very expensive for your heirs. So what would you want your attorney to include? So one thing that you can take a look at is if it's going to be a flat fee package that offers you updating, as I mentioned, the family wealth inventory so that no assets are lost. And another thing that I also recommend to clients is putting together a list of your passwords. Even though they might change, at least they've got a good idea on it, or otherwise you're going to be ending up with not only a scavenger hunt, it's going to be playing Jeopardy to decide, okay, have I got the right password or am I going to be locked out? So the other thing that I mentioned is, updating your plans every 3 years and to have that ongoing relationship with an attorney, to have an inventory of your financial assets, to make sure that your kids are properly planned for, and coordinating also between generations. So a point to think about here for planning between generations, some people, if you just have a will and say you've got kids that are, maybe 18 or just under 18, as soon as they turn 18, they're going to get that chunk of money. Some kids can handle it and some kids can't. And so that's something to also think about. And another good reason that you may want to think about having a trust for some of your assets, because if you have it in the trust, you can design that trust. We can design that trust so that you can have it come out in what I call ages and stages. So for instance, at such an age, at 18, maybe they get money for college, for trade school. At another age, they get another chunk of money so that they could purchase a home or start a business. And then maybe at another age, the trust can be dissolved so that they can get the rest of the money. But also for some people that have a large estate, the sooner that if you have such a large estate as you're bringing your children in, if you start to get them educated sooner rather than later, get them together with your financial advisor so they know how to manage the money. Some kids don't, but some kids do, but some kids not so much. And so by getting these protections in place, you're protecting your kids not only when they're young, but also when they're older. So what to do if you are at risk, if you don't have any of the documents, come in for life and legacy planning and I can review your plan or the state's plan with you and make sure that you've got all the right documents. We can go through with your family wealth inventory because some people a trust is appropriate and some people a trust is not appropriate. And then if there's holes in your plan, we can go through and make sure that we've got that done. Now, another thing that I'd like to talk about, because what group are we in? We're in Mountain Women in Business. So setting aside the estate and will planning, let's take a look at business continuity. So with the business continuity, one of the things I like to discuss with my clients is what kind of business do you have? The reason why that's important is taking a look. Are you a single member LLC? What does your operating agreement say if something should happen to you? What happens to the business? If you're a C Corp or an S Corp, what do your corporate documents say of what happens with your business should something happen to you? Another thing to think about with business continuity is where are the passwords for your business? Do you have them stored someplace? So if something happened to you, who could take care of your business? And that's why that durable power of attorney is so important, to have that in place for your business. Also, who gets into your bank accounts? One of the things that happens when you're an attorney is we do what's called succession planning. So we've got a tag team attorney that could step in should something happen to us. And I have that set up for my law firm. But one of the reasons why I started my law firm back in 2018, I got a call from a client and he asked, "Are you still doing law?" And I said, "Yeah. What do you need?" He said, "Well, our attorney might be dead." And I said, "Okay, well, let me know." So about a half hour later, I got a call and he said, "Okay, the attorney's dead. Can you come in and interview?" I said, "Well, not today, but I can do it tomorrow." Turned out that, yes, the attorney was dead, but the sad thing was that the attorney had no continuity. So I had to work with the Office of Attorney Regulation to basically wrap up his books for his law practice to make sure all of his clients were taken care of. If there was a trust account, that the money went back to the right people. If there was a business account, to make sure that that money went to where it was supposed to go, to his heirs, or after everything was wrapped up with the business. So it's important as you look at your business continuity, is taking a look at who would step in should something happen to you. Not necessarily if you're dead, but if you're incapacitated, who is there that could step in to take care of you? Have that backup partner that would know what should happen for your clients. And with that, it's going to make your life easier. It's going to make your client's life easier. And it's going to make sure that you actually have business continuity for your business. So the next steps that I'm recommending, if you'd like me to help you out on that, drop your email in the chat and we can connect. And we can take a look at what documents you have and what else we need to kind of do some belt and suspenders to make sure that your estate plan is doing what it needs to do for you. Any questions from anyone?
Yeah, I have a question.